Good afternoon, everybody, and happy hump day. Hope you're having a wonderful day, and I can see the weekend coming from here. Yep, above on this slide is our website and the webinar website. If you haven't taken the opportunity, please take a look at it. And there are many recorded seminars on there. I think somewhere upwards of between 2 and 3 dozen. You can listen to those and also obtain continuing education credits. Additionally, we issue a blog, a newsletter every month or so with updates on the law, statutes, case law, etc. Please contact Tammy Welty and sign up for that and take advantage of that opportunity. We are on social media, and if there's any way, you feel free to contact us in any of these ways. I've never Instagrammed, I've never tweeted, and I barely know about Facebook, but people brighter than me with the law firm know all about that and can assist. All right, CTs. We're going to talk about continuous traumas, and we're going to start out very slowly. In the first 3 minutes, you might think there's really no reason for me to sit here because, well, I learned this within the first week at my claims desk. But I just want you to know that I recognize that, but we're going to speed up quite quickly, and hopefully this will be valuable to anybody who's been doing it doing workers' comp for a week to a half a century. You may have noticed, if you've been doing this for a little while, that CTs are on the rise. Here's an article from Work Comp Central just last year. We've doubled in CTs over the past 10 years. So I think it's all the more important that we learn more about the CT and exactly how to defend against the CT and diminish our liability or exposure. So at this point, nearly 20% of the applications for adjudication of the DWC-1 claim forms involve a CT. The numbers are just astronomical. And of course, the troublemakers, those of you in Los Angeles know who you are. That's where some of the crazy filing is. The vast majority of CTs, or the higher number of CTs, are filed in LA County as compared to other counties. If you take a look at LA County, for example, for the period of 7/12 to 4/16, there were 336 CT claims exceeding $1 million. And there's some further interesting statistics here. Of 148 cases in that period of time, they were worth they cost the county $243 million. So continuous traumas are obviously a huge potential exposure and something we need to know more about, which is why we put this presentation together. The continuous trauma, or why I stopped worrying about that darn thing and started loving the CT as a defense weapon. All right, as I promised, we're going to start out very slowly. What kind of injuries can we possibly have according to the labor code? I'm not talking about low back injuries or carpal tunnel or shoulder injuries. I mean the two kinds of injuries we have. Obviously, we have specific traumas. And secondly, that leads to the name of the title of the presentation. The other kind is, of course, cumulative traumas occurring as a repetitive, mentally or physically traumatic activity extending over a period of time. And what's the date of injury? Well, for a specific, it's real simple. It doesn't really take a genius to figure that one out. It's the day that you fell down. It's the day that you bumped your head. It's the day that you were hit by the car. It's the day that you got the boo-boo, applicant. Have you ever felt that you had this specific down at the office? I know I feel like this on a regular basis. Now, what about the continuous trauma? What's the date of injury for a continuous trauma? I know I often ask this question in presentations, and people say something about the last year of exposure, or sometimes they say the entire. I gave this presentation yesterday to a group, and somebody said, well, it's the entire period of employment, or it's whenever the applicant feels it is. But I know that's how it's often filed, but that doesn't necessarily make it the case. Let's take a look at what the definition of a continuous trauma is. We're not going to look at a whole lot of statutes because I just don't like looking at statutes. They're really kind of boring. But this is one of the ones that we really need to know, 5412. Continuous trauma, date of injury in cases of occupational diseases, whatever that is, or cumulative injuries, is the date upon which the employee first suffered disability, whatever disability means, and knew or should have known that that disability was AOE, COE. First suffered disability, knew or should have known that it was work-related. So what is disability? Real simple. We have exactly two kinds of disability, and everybody should be able to answer that question right off. We have temporary disability and permanent disability. So let's look back here at 412. The continuous trauma, the date of injury, is the date upon which the employee first suffered from temporary disability or permanent disability and knew or should have known that that temporary disability and or permanent disability was AOE, COE. What else qualifies? Well, actually, nothing else qualifies. Modified work may be evidence of temporary disability or evidence of permanent disability, but that evidence alone will not win the day. We're going to have proof of temporary disability and or permanent disability. Similarly, medical treatment alone will not rule the day. It can be used as evidence of permanent disability or temporary disability, but we're still going to need further evidence. Now, these questions, which require a doctor to address, are for the trier of fact to determine. In other words, these are for the judge to make the determination. Now, got an interesting picture here. We've got a bunch of dogs playing poker. And there's a reason. I mean, it's a cute picture, and I certainly like the picture, so that's one of the reasons I included. But the other reason is to sort of make a point. I want you to keep this in your back of your mind. Imagine if you play poker, or you know somebody who plays poker, or you can spell poker. You have some sort of idea how it goes. And there are 2 of a kind, 3 of a kind, 4 of a kind. Royal flush is the best you can possibly do. Imagine this. You're at your home and you're expecting friends to come over to play poker with you. And just before they come over, you put the pretzels on the table, and you put the chips on the table, and you put the cold beer on the table, and then you shuffle the deck and you start distributing the cards without them there. And you look at the first card and say, oh, that's a 2, I don't want it, and you pass it off to somebody else. And you look at the next card and it's an 8, so you say, I'm going to take that one. And you go through the entire deck that way, and you find coincidentally, you end up with a royal flush. How are you going to end up doing in that hand? Well, you're going to do very well. In fact, you're guaranteed to win. And that's kind of an analogy to workers' compensation, the continuous trauma, and being elected again. Often people say, I don't want to be elected against because that's going to mean more work for me. Well, it's also going to mean that you may be able to deal the cards to your advantage, and just keep that in mind, and we'll go a little more further in detail of that later. So, what's an occupational disease? We saw that in Labor Code Section 5412. Sounds like something you don't want to be next to. You don't want to be next to somebody on the bus who has an occupational disease. Actually, it's a trick question. It's not statutorily defined. It's interchangeable. It means it's basically the same thing as a continuous trauma. There is no difference. Just like these twins, there's no difference between them. By the way, I have this slide here because, number one, these are twins, so there is no difference between them. And 2, it's just a cute picture, isn't it? Doesn't it make you feel warm and cuddly inside? Now, speaking of which, we've got Labor Code Section 5500.5. It applies to both continuous traumas and occupational disease. But what does 5500.5 say? Well, I know we've all heard about it, and I know a lot of you are thinking last year of injurious exposure, and something about a year CT, and about maybe occupational disease, and maybe something about a statute of limitations. And oftentimes I'll give this presentation, and that's about all I hear is those observations. So there's maybe just a little bit more to Labor Code Section 5500.5 than we're immediately able to think of or conjure up. Actually, here's what it says. It says this, and it says this, and it says this, and this, and then they say a little bit about this, and that, and that, and this, and this, and this, and that, and that, and that, and that, and it keeps it going. There we go. That's what it says. So it says a little bit more than something about the last year of injurious exposure or 1-year statute of limitations. So I think given all that information in that one statute, Labor Code Section 5500.5, it might be worth our while to take a little bit of a look at it. Now, we are clearly not going to look at all of 5500.5. That would take it would take at the very least several hours, and perhaps longer. But let's take a look at the highlights, shall we? Let's get to the interpretations. Except as otherwise provided, the period of a CT shall be 1 year. So if your date of injury is on or after January 1, 1981, it's going to be, the CT will be up to 1 year. Note the very beginning of the language, except as otherwise provided. Can you imagine what situations are quote unquote otherwise provided? I'll give you a hint. Those situations are only litigated at 2 WCAB district offices in the state of California, Oakland, and Long Beach. If you guessed asbestos, though you're absolutely right. If you've not dealt with an asbestos case, the CTs for asbestosis can go back during the entire period of employment for the applicant. So it can go back 10, 15, 20, 25, 30, 40 years, and that really does happen. So you may have dozen or 2 dozen co-defendants involved. Thankfully, we don't have that kind of complication for all the other types of injuries that we deal with. What else is 5500.5? We'll read it real quickly, and then we'll get to interpretation. In the event that none of the employers during the above referenced periods of occupational injury or disease are insured, liability shall be imposed upon the last year of employment for wherever the employer is insured. So, time to translate, what does that mean? If nobody has coverage or is permissibly self-insured for the last year, for the continuous trauma itself, regardless of whether it is the last year of injurious exposure, we're going to go into our Wayback Machine and go back to the employer or employers who are so covered or who do so qualify as being PSI. Liability shall not be apportioned to prior or subsequent injuries, or subsequent years rather. What does that mean? Once you find your 1 year CT, that's it. We're not going to apportion to prior days, weeks, months, or years. We're not going to apportion to subsequent days, weeks, months, or years. Now, that doesn't mean we can't have more than 1 CT. It's quite possible to have 2 CTs, 2 2-year CTs, maybe even 3 2-year CTs, or 3 1-year CTs. That's not something that we're going to go over today, but I want you to be aware of that and put that in the back of your head. Maybe we'll address that in some later presentation. In fact, if you're so interested, please let me know, and I'll be happy to develop a program on exactly that. All right. In any case involving a CT as a result of more than 1 employment, the employee may elect to proceed against any 1 or more of the employers. The interpretation, if there's 1 or more co-defendant, the applicant can avoid being gang tackled by simply saying, I hereby elect against this defendant or that defendant. And that's who they're going to be dealing with up front. The way that the applicant normally elects against a defendant who is the tail end carrier, or at least who is perceived as the tail end carrier. Oftentimes that changes, and we'll see about that when we go over the Western Growers case in a few minutes. Either the tail end carrier and or the carrier who has the greatest exposure. When the election is made, any award shall be joint and several against any 2 or more employers who may be held liable. What does that mean? Well, let's continue to read a little bit more. Any employer joined as a defendant subsequent to the first hearing or subsequent to the election provided herein shall not be entitled to participate in any of the proceedings prior to a final decision, nor to any continuance or further proceedings. What does that mean? Time to translate that. Well, co-defendant was elected against, you weren't elected against, you are absolutely entitled to sit down and shut up and wait until there's a final decision. That's absolutely true. You don't get to do anything in terms of discovery. You really have no rights and you're flying naked. It's kind of an uncomfortable position. I remember about nearly 30 years ago, I was in a deposition. I was just fresh out of law school. and I was representing the defendant who had not been elected against. We were at the deposition, and the lead defendant asked a bunch of questions, and then it was clear that he was done asking questions. And I said, well, I have a few questions. And he said, no, you don't. And I said, no, yes, I do. I have some questions. And both he and applicant's counsel in unison said, no, you don't. And of course, I was upset about this. I thought, and I started spouting off about due process and my client's rights because, well, I couldn't think of anything better and to say. And these are the few things I can remember from law school. And then after they refused to let me ask questions, I went back to the law firm and talked to one of the senior partners, and he informed me, that's right, Barthel, you've got absolutely no right. You've got to wait for a final decision, at which point then we can conduct some discovery. Upon supplemental proceedings, however, after there's been an award, a final award, the right of the employer to full and complete examination or cross-examination shall not be restricted. Time to translate that one. Once the damage has been done, once the final decision has issued, feel free to undo the damage. Now, let's think back to my analogy with the dogs playing poker. Once the damage is done in that situation, once you've dealt the hand and have already given yourself a royal flush, now it's time for your neighbors who are going to be attending the game to try to undo the damage. Not a very great likelihood that they're going to be able to do so. So we're going to talk about doing exactly that, learning how to deal the cards to our advantage as the elected against party, and set our co-defendants to a disadvantage, and either get more money out of their pocket or decrease the amount of exposure that we and our client actually have. There are significant advantages to being elected against, and we're going to again outline that more in Western Growers. People often say, well, I don't want to be elected against. That means more work. I've already got way too much work. And that may be absolutely true. And if we have a low exposure case, if this is a $5,000 or $10,000 case, I don't think there's any great need to be elected against. Let somebody else incur the legal expense. But if the case is of any significant value, I strongly recommend that you do your very best to be elected against, to incur that extra load of work, because it's going to give you an opportunity to save your client a great deal of money. On a side note, in terms of being elected against, there was a panel decision recently in which there were 2 co-defendants and 1 continuous trauma. Applicant's counsel decided not to elect, but just to go against both of the co-defendants at one time. And the question was, is that allowed? And the answer is yes. And the second question was, may each of the co-defendants get their own QME? And again, the answer was yes. And the question was, let's think about this. As the applicant's counsel, why would they decide not to elect against one of the defendants? I mean, if you don't elect, you got to get ready to face the teamwork, 2 or more co-defendants working together. You know, if one co-defendant doesn't remember a defense, a statute of limitations defense, or a going and common rule defense, or what have you, invariably the other co-defendant is, and they can work together. So you're definitely going to be facing that, as well as multiple QMEs in each specialty. On the flip side, the upside is, especially in denied cases, there may be one party that's denied it and another party that's accepted it. Obviously, the party that has accepted the claim is going to be elected against. And moreover, if the applicant fails to elect, as suggested just by this case, each co-defendant is allowed to get a QME. Well, if there are 2 or more QMEs, presumably they are not going to be exactly the same report. One of the reports is going to be more attractive, more beneficial to the applicant. And at that point, he or she is in a position to adopt that report and elect against the defendant with the best medical report, the one that is most favorable for them. All right. I want my money back. Congratulations. You've done a great job. You're the lead or only defendant. You've settled the continuous trauma. You're only partially on risk for the CT. Now what do? Talk amongst yourselves. Okay, very good. You send a letter. I want my money back, says you. New term, contribution. Hopefully this is familiar to most of you. Dear employer, carrier, TPA, I've done some math. You owe me $60,000. Please send now. Love and kisses, lead defendant. You know, there just isn't enough love in workers' compensation. So I dare you to send a letter sometime to a co-defendant saying love and kisses. And there's just not enough entertainment in California workers' compensation, and dropping one of these is always fun. You know, I was telling somebody the other day, our law firm is Bradford and Barthel, Barthel, and of course, everybody pronounces Bradford correctly, and everybody spells it correctly, pronounces it correctly, and my name always tends to get butchered, which is just fine. But about 15 years ago, we got a letter addressed to the law offices of Bradford and Barthel. And while we are a full-service firm, we really haven't opened that office outside of Las Vegas yet, so we're not that full service. So again, there's lots of we got to look for entertainment where we can find it. So let's go with that love and kisses letter. So anyway, you've done some math. Co-defendant, you owe me money. Please send it now. Very nice letter, very polite. Now you wait a while, and you put it on long-term diary, and you wait a little longer, and a diary comes up, and you put it on a little longer-term diary. Well, if you wait long enough, the Donald is going to come down the hallway, look at you, point his finger at you, and say, you're fired. Now, actually, he's probably not going to do that because he's probably now president. He's president. He's probably busy with that, too busy to do the apprentice show. But were we still in the apprentice show era, he'd be coming down and telling you were fired. Now, why would you be fired, pray tell? If you're saying something about a statute of limitations, you're absolutely right. If you've waited too long, you've missed the statute of limitations. When does the clock start ticking? Let's take a look at the statute. After the appeals board has made an award for compensation benefits in connection with an occupational disease or cumulative injury, any employer or insurance carrier held liable under the award may institute proceedings, whatever that means, institute proceedings before the board for the purpose of determining the apportionment of liability or right of contribution. So, after an award has issued, we may institute proceedings for contribution. Now, what does this mean? How do we institute proceedings? Does filing a CNR with an order approving do the trick? Absolutely not. That does not institute proceedings. What about joining the co-defendant for purposes of contribution? Nope, that still doesn't institute proceedings. What do you need to do? You need to file the petition for contribution. And file it right away. You certainly don't want to meet the Donald, and it's just too easy to miss the 1-year statute of limitations. People often tell me, well, you know, I don't have all the numbers. I'm still, you know, waiting to get all the benefit numbers together, and so I want to attach that to my petition for contribution, and I'll get to it then. Well, that's not legitimate. You don't need the numbers or the final numbers. You can draft a skeletal petition that basically says this is a petition for contribution. I think you, co-defendant, owe me money. Further numbers to follow. At that point, you've told the statute. You've done absolutely everything you need to make sure that you don't see the Donald anytime soon. Moreover, it can get complicated. Imagine this. Imagine you go to trial on January 1, 2000, and well, just make it January 1 on the issue of temporary disability. And you're not represented by the law offices of Bradford and Barthel, so you lose, of course. And let's say the judge issues the FNA on January 1. Well, now you have a 1-year statute of limitations to file a petition for contribution from January 1 to January 1. All right, let's say you go to trial again on, what did I say? I said temporary disability. Let's say you go to trial on permanent disability on March 1, and you lose again, and the judge issues the FNA on March 1. Well, now you have 2 statute limitations, one from January 1 to January 1, one from March 1 to March 1. Let's say again you go to trial on June 1. Again, not represented by the B&B, so you lose again, unfortunately. The judge issues the FNA on that day, and now you have 3 statute limitations, 3 balls in the air all at the same time, 1-1 to 1-1, 3-1 to 3-1, and 6-1 to 6-1. Why in the world would you expose yourself to possibly missing one of these dates and keeping all these balls in the air when you can simply file a skeletal petition for contribution, cut off any potential liability for missing the statute of limitation? It's just too cheap, too easy to avoid that. So please, 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 as soon as you get an award to any benefit, please file your petition for contribution. So let's go back to that statute, shall we, real quickly. After the appeals board has made an award of benefits, we may institute proceedings for contribution. What is an award of compensation benefit? Well, it can be absolutely anything. Any type of benefit, pick your poison. We can be untimely in terms of the statute of limitations, even if the award is not final as to quote unquote all benefits. It could be any one benefit, as suggested by my example just a couple of seconds ago with the losing the trial on January 1, March 1, and June 1. It can be an award finding no T or no PD, but just need for medical care. I think we've made that the June 1 to June 1 example. A petition filed within 1 year of the CNR, but not the award, except as to additional benefit. There's statute starting again. Lots of case law on this, so we need to remember to file the petition, file it timely. So now that we filed it, and we filed it timely, and the co-defendant knows how much we're expecting, we've finalized the petition, we know exactly how much we've spent. We ask for the whatever amount of money we think is appropriate. And we'll talk more in a little bit as to what we might think is appropriate and how we're going to calculate that. But once we've done that math, we can simply enter into settlement negotiation. Hey, I've spent $100,000. I've got 6 months exposure. You've got 6 months exposure. I think that you owe me $50,000. Reasonable minds can prevail, and the matter is resolved in a matter of minutes. But what if you can't come up to a conclusion and get a reasonable resolution? Well, at that point, we can't go to the WCAB district office. The judges nor the PJ want to hear from us. We are legally in fact, they'll probably either laugh at you or yell at you if you go down to the board with the expectation that a WCJ is going to resolve your contribution issue, because the labor code says there are 4 different issues that we must use arbitration on. There are 4 mandatory arbitration scenarios, and one of them, 5275A2, the right of contribution in accordance with Labor Code Section 5500.5. So we're going to be doing arbitration. If we can't settle, arbitration is our only resolution. At least initially, it's our only resolution, our potential for that resolution. More to that to follow. So where do you find an arbitrator? Well, sort of like an AME. If you can find somebody that everybody agrees to, that's wonderful. If not, you can go to the presiding judge and they will have a list of qualified, available arbitrators, and you can agree to select from any one of those. And who is an arbitrator, or who can be an arbitrator? Well, first they have to be a member of the state bar. They've got to be an attorney, and they've got to be in good standing, so their bar bar number can't be revoked from them. And 2, they can either be a certified specialist. A certified specialist is just somebody who's taken an extra test, has to take additional continuing education credits, and presumably knows a little bit more about the law than a general. So active member and a certified specialist, and or a retired workers' compensation judge, and or a retired WCAB appeals board member, not a lot of them doing this, or a judge or an attorney who's been certified to serve as a judge pro tem. These are the folks that go down to the board and assist the board maybe once a month or twice a month. If you've ever seen a 5710 fee award signed and you look at it and said, I don't recognize the name of that judge, he or she is not a regular judge down at the board. That's entirely probably true, and it's entirely logical and likely, rather, that that is a pro tem, somebody who's been certified to assist the board with its overloaded caseloads. Overloaded caseloads. That's only semi-redundant. So, how do you pick your arbitrator? Well, let's say you can't agree to one. Well, then we can get a panel. We're all used to striking from panels for QMEs now. We're all expert. Well, with the arbitrator situation, we'll get a panel of 5 arbitrators selected at random. You strike 2, they strike 2, and the remaining remaining attorney is going to be your arbitrator. What can an arbitrator do? They could do anything. They can do absolutely anything that the judge, that your WCJ down at the board can do, with 2 exceptions. They can't order that the applicant undergo an independent medical examination, and they cannot issue a contempt order. Makes sense in terms of the IME. After all, once you're at the point of a petition for contribution and fighting that issue, all the medical discovery is complete, and the applicant is probably out of everybody's hair. It's just a discussion between co-defendants as to who owes whom what. So no need for additional medical evidence once we're getting in front of the arbitrator. Who pays the cost for the arbitration? Well, if you've been in the industry for more than 37 seconds, I'm sure you know exactly who pays the costs. We do, and it's split up equally between the parties. So if you have 2 parties to the petition for contribution, you're going to split it 50-50, 3, 33 and a third, et cetera, et cetera. Where's the arbitration? Well, everybody can agree to it, any place, anytime that everybody agrees to. Alternatively, if you can't agree, that's going to be left up to the arbitrator. And it shall commence not less than 30 days, no more than 60 days from the date an arbitrator is selected. What if the arbitrator says, I want to do it in 65 days, I'm really busy? I recommend that you go do it in the 65 days. You don't want to spit in the eye of or be disagreeable with the person who holds your future in his or her hand. Similarly, although you're supposed to, per Labor Code Section 5276A, or C rather, submit your evidence to the arbitrator 10 days prior to the arbitration, if the arbitrator tells me they want it 50 days before the arbitration, the arbitrator is going to get it, at least from me, because I don't want him or her upset with me just before we go into the arbitration. This is an interesting question. How long do we wait for the arbitrator's decision? Now, I know when you go down to the board and you go to trial and you wait, it seems like forever for the F&A. And I know when you file a petition for reconsideration up to the commissioners in San Francisco, it sometimes feels like you have to wait forever and a day to get the decision. And if you've ever gone up to the District Court of Appeal, it too seems like it takes forever and a day to get a resolution. How long then are you going to be waiting for the arbitrator's decision? Well, here's the fun answer. 30 days. And I pretty much guarantee it's going to be 30 days. Why, pray tell, is it going to be only 30 days? Real simple. Follow the money. Follow the money. Unless all parties agree to a longer period of time, the failure of the arbitrator to submit the decision within 30 days shall result in forfeiture of the arbitrator's fee and shall vacate the submission of order and all stipulations. Now, I'm not recommending that as soon as any arbitrator delays an arbitration decision beyond 30 days that you object and do it all over again. Obviously, that's entirely ineffective, or at least a delay tactic that's helpful to absolutely nobody. Just incur unnecessary delays. I'm talking about the situation where the arbitration went very poorly for you. A witness didn't show up, evidence was missing, something went very badly, and you are praying that you can somehow get out of this arbitrator's hands. Well, at that point, you calendar the thing and hope that the arbitration takes more than 30 days. As soon as you're on your 31st day, you object, let everybody, the arbitrator and the other parties know that you're objecting, and thank goodness you've got an escape hatch and you get yourself a new arbitrator. Your co-defendants are not going to be happy with you, but that's really not your problem in this particular situation. All right, we said that the arbitrator can do absolutely anything that a judge can do except issue a contempt order or order an IME. So stands to reason that if you don't like the result of an arbitrator's decision, you do exactly what you would do if you don't like a judge's opinion and you want to appeal it. You file a petition for reconsideration, of course. All right, take charge. Move the CT. Let's take a look at Western Growers, a case that came down in 1993. Let's do a little quiz, though, first. And you've got to get all the answers right, or otherwise you are hereby fired. The Donald is going to come down and say you're terminated. No, I guess Arnold Schwarzenegger said you're terminated. The Donald says you were fired, correct? I don't know. I'm getting my Terminator / firers confused. All right. You're in the entire CT as pled, or you're sharing the CT with co-defendant. Do you want to increase your co-defendant's liability? Absolutely. If that saves me money, I'm more than happy to increase my co-defendant's liability. Would you like to increase the amount of money that goes into your client's pocket? Sounds good to me. Absolutely. Once again. Would you like to totally eliminate your liability? Once again, this sounds fabulous. So far, we are 3 for 3. Would you like to decrease all the co-defendant's liability, including yourself? And proviso here, in order to decrease your liability, you have to decrease everybody's in this particular scenario. And of course, I'm more than willing to save everybody money if it means that we get to save money as well. So the answers are yes, 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 and yes, and hopefully you got all 4 yeses. Now let's one more question. If there's only one specific and you have coverage for the date of the specific, would you like to share your liability with others and diminish your exposure? I think once more the answer is yes. So if you have 5 yeses on your paper, congratulations, you get to keep your job. Well, let's again talk about Western Growers, also known as, Judge, you got the wrong defendant, aka dumping liability on somebody else's lap. This case came down in '93. I remember I was down at the Santa Ana board when this case came out, and everybody was scratching their head and trying to figure out what Western Growers actually meant. The name of the case is really Austin, but everybody knows it as Western Growers. This applicant was employed by the same employer for a quarter of a century. Not surprisingly, working there caused a major recurrent depression. I think working somewhere for a quarter of a century might cause me depression as well. The bad news is Bradford Barthel's been around for 20 years, so I guess I'm 5 years away from it. So after 25 years, we've got depression. At 1985, symptoms first appeared. June of '85, was admitted to a mental health institution for 16 days and suffered from temporary disability. He later at trial said, "Yeah, when I went into the mental institution, I knew that it was work related." Thereafter, he returned to his UNC. Things got worse. Couldn't work. Ordered off work. Hospitalized again in '88, and permanent stationary in 1991 rather. So let's take a look at the chronology. Hired in 1962. Hospitalized in June of '85. I should say not believed, injured worker believed, and injured worker said he knew that it was work related. Returned back to work the following month. A year and a half later, ordered off work. The following year, hospitalized, and a couple of years later, determined to be MMI or PNS. Who was on risk? Well, Western Growers was on risk after the 685 hospitalization through to the last day of work. Industrial indemnity was on risk from the date of hire through to and including the June of '85 hospitalization. So basically, industrial indemnity is on exposure. It's exposed from 62 to just up to and including this June '85 hospitalization. After the hospitalization in '85, all the way through to '91, so almost 6 years, over half a decade, Western Growers is tail end carrier. We talked about being the tail end carrier. This does not look for Western tail end carrier and 1 year exposure. This does not look good for Western Growers, does it? The judge found, well, we've seen this before, haven't we? A CT for the entire 25 years. And because Western Growers was the tail end for the last, not only year, but for the more than the last half decade, Western Growers was stuck with absolutely everything, all the PD, Everything, the only thing that I was nailed with was the June '85 hospitalization when, of course, they had coverage, so that made sense. The WCAB agreed with the WCJ, and Western Growers happily appealed this thing to the District Court of Appeal. And the issue, according to the District Court of Appeal, was who is liable? In other words, what is the date of injury, quote unquote? In other words, who provided coverage during the year preceding the date of injury or the last day of exposure, whichever occurred first? Now, I don't know if you're like me, but when I read a sentence like that, I get confused. So I try to break it down. Whichever occurred first. Apparently, whoever the party that's in trouble is the party that had these events occur first. Well, we know the date of last exposure. We know who had that, and that was Western Growers. The only question is, what was the year preceding the date of injury, and who was that? So we've got to identify who was the party that had exposure during the year preceding the date of injury. In other words, what was the date of injury? And the Court of Appeal said the judge got it wrong, as well as the WCAB. The crucial date, they said, was in 5500.5 is, as we just saw on the other slide, the date of injury or the date of last exposure, whichever occurs first. What's the date of injury in this case? I'll give you a couple of seconds. Okay, what's the date of injury? Did you say June of '85? If you did, you're absolutely correct. Now, why is June '85 the date of injury? Real simple. Had disability, he was hospitalized, obviously. Remember, permanent disability or temporary disability would qualify as disability in this situation. And remember the rest of it, knew or should have known that it was work-related. At a later point in time at trial, he said, I knew that my hospitalization was work-related. So disability, knew or should have known. Hospital is in June of '85. The date upon which the employee first suffered disability therefrom, and either knew or should have known that such disability was caused by his present or prior employment. So what happened to Western Growers' liability? It completely disappeared. What happened to industrial indemnity? They lost. They got stuck with absolutely all the exposure. Can you imagine that poor adjuster at II thinking that they've got it made in the shade? They cannot believe that Western Growers is appealing this thing all the way to the Court of Appeal. The judge has proven that they've got it wrong. The WCAB says they've got it wrong. The adjuster's reading of 5500.5 says they got it wrong. And then the Court of Appeal says, nope, here's the real way, here's the correct way of interpreting these relevant labor codes and provisions. Now, I said a couple times that not only did the WCAB and the District Court of Appeal say that the applicant believed that the injury was AOE-COE, but that he knew that it was AOE-COE, and there's a reason for that difference. The WCAB will generally not impute knowledge without medical evidence. Boy, oh boy, is that true. In fact, you can almost take out the word generally and simply say the WCAB will not impute knowledge without medical evidence, unless, and here's the verbiage from the Johnson case, the applicant has training, intelligence, and qualifications, and that word is and, not or, that are such that the applicant should have recognized the relationship between the known adverse factors involved in his employment and his disability. Now, I once saw a case maybe a quarter of a century ago, and I can't find it for some reason, but I recall the facts quite well, in which a workers' compensation judge was found to have not known that his injury was work-related until a doctor told him. So if a workers' compensation judge is not going to be found to have the necessary training, intelligence, and qualifications to have knowledge imputed, I don't think the vast majority of your applicants are going to be so found. In fact, what's the upshot here? The WCAB virtually never imputes such knowledge without a medical opinion articulating industrial causation and evidence that the applicant was told by a doctor or read the medical report demonstrating AOE-COE, that there was AOE-COE. The Johnson case, the applicant actually didn't claim to have knowledge, but said that he believed that the injury was work-related. Even with that, the WCIB said that's not sufficient to qualify as knowledge or should have known. In the Scholar case, we had a 4-year history of treatment for carcinoma. It was held that there was no knowledge because Mr. Scholar had not been told that the carcinoma was work-related. Now, the case that I just love, the Darling case, is really darling. You're going to be outraged by this one. It was a police officer that worked from 69 through 90. There's a typo here. That shouldn't be a number 6. It should be an L. Last day of work was in 1990. I noticed a swelling 4 years after his neck, 4 years after he left the job, which was diagnosed the following year as Hodgkin's disease. In 2005, he filed a claim form saying, this is work-related. I mean, that's what a claim form says, right? I am filing a claim form because I have an injury, and I'm alleging work-related. So although he filed a claim form with that obvious message, he wasn't told by a doctor that it was work-related until 2 years later in 2003. The holding was the CT went through 2003. Now, I can't believe this case. When I file an application for adjudication or a claim form, I'm going to be arguing that 1, I've been injured, and 2, it was at work. To suggest that I'm filing a claim form but don't know that it's work-related is to suggest that I'm being fraudulent, I would think. Anyway, this Darling case just demonstrates how extreme a position that the WCIB takes on this score. So, what are some of the pointers to be taken away from Western growers? Don't believe the application for adjudication. Although it may say one set of dates, that doesn't necessarily mean that's what we're stuck with. I know we often use an application for adjudication or DWC-1 claim form as a shorthand, saying, okay, well, I've seen the application, I see the date of injury being alleged, I'm in there or I'm not in there, I'm only partially in there. But we know, for example, from Western growers that doesn't mean necessarily anything. Western growers, I can imagine the adjuster on Western growers thinking that they had total exposure, and until the evidence was taken in, didn't know that they actually had no exposure whatsoever. So the dates of injury listed on the application for adjudication means absolutely nothing. In fact, it's not evidence of anything. An application for adjudication and a claim form are pleadings. They are not evidence of anything. I had a friend who once said, I can plead a bologna sandwich. And the meaning of that was, you can plead anything. It doesn't matter. It's a bare bones allegation. This is an interesting problem. So let's say you've got a 1-year CT, you're the tail end, and you've got the last 6 months. Your co-defendant has the first 6 months. You spend $100,000 on the case. How much are you going to be looking to your co-defendant who has equal exposure, exposure equal to you? Well, presumably half of that $100,000 or $50,000. That seems fair. And the truth of the matter, that's what we've always done. We've had the respective employer liability based on the period of exposure, not degree of causation. But let's talk about a different potential option. Let's say the same fact pattern for the most part. 1-year CT, you're the tail end. You have the last 6 months. You spent $100,000 on it. But during the first 6 months of exposure, the applicant was lifting 100 pounds 20 times a day and using at all other times a pick or a shovel, and of course has a bad back. Tweaks the back the day before your exposure, and immediately thereafter is put on a mod work in the office filing papers. So you do have exposure on this 1-year CT, but how much are you going to accept? If you spend $100,000, how much are you going to look to obtain from your co-defendant if arduousness is considered? Well, if arduousness is considered, I'm going to be looking for the vast majority of that $100,000 to be given to me by the co-defendant. Now, that's not how we normally do it. We normally do it by the period of exposure, and that's based upon the labor code. Quote, the respective contributions of such employers, or rather such insurers, shall be in proportion to the employment during their respective periods of coverage. Well, note the word former. This statute was eliminated before I think any of us in this presentation were doing workers' compensation. I was, I think, 16 years old at the time. That's not the rule anymore. We can still take a look at the degree of arduousness. And there's actually case law to that effect. So if you're facing that kind of scenario, by all means, point out to your co-defendant who you want more money from that the statute that they think still exists, that's 5500.5D, has been gone the way of the dodo for approaching half a century. All right. Every specific needs a CT for apportionment purposes. Why celebrate the CT? Well, you show me a CT and I'll show you opportunities for apportionment. And good Lord knows we like apportionment. Those of you who remember apportionment prior to SB 899, you remember that we never got apportionment unless the applicant was totally honest or we caught them in the middle of a fraud claim. Other than that, although there were apportionment laws on the books, they were never effective for a whole host of reasons. Now that's not necessarily true, and the truth of the matter is, subsequent to SB 899, we've had WCAB en banc decisions and District Court of Appeal decisions that, in large part, have strengthened Labor Code Section 4663 and 4664 apportionment statutes for the defendants. That is. Let's take a look at the Anderson case. It's been certified for publication, which means it's the law. All the WCJs and the WCAB commissioners have to follow it. The doctor apportioned away 30% of the permanent disability under Labor Code Section 4663. So the quote-unquote approximate percentage, end of quotes, of the permanent disability that is not AOE COE is 30%. That's the language, approximate percentage. That's the language found in Labor Code Section 4663. He found that the permanent disability at work was due to gripping, grasping, manipulating, pulling, etc. But the non-AOEC permanent disability was due to the quote-unquote regular activities of life. Now, this case came down shortly after we started using the AMA guides, and this was an AMA guides case. Are you familiar with the phrase that's very similar to regular activities of life that's found in the AMA guides? That's right, activities of daily living. And activities of daily living is what impairment is based upon. So in fact, point of fact, the doctor was apportioning to activities of daily living, driving, occasionally moving furniture, all the things that are listed on page 4 of your AMA guides. The doctor admitted that his apportionment determination was speculative, and oftentimes you hear applicants' attorneys saying, hey, that's speculative, you can't rely on it. That's a bunch of baloney. Of course it's speculative. There's no way of measuring objectively the doctor's apportionment determination, so speculation is okay as long as it's based upon a reasonable medical probability. The only question was, is this apportionment to activities of daily living substantial evidence? And the answer was, according to the District Court of Appeal, yes. Now, the editor, this was reported in the CWCR, and the editor weighed in after it. And the editor is more of a California Applicants Attorneys Association fan than a defense fan. Here's the editorial that the editor provided, and I find it interesting that although the editor is pro applicant and I'm on the defense side, we nevertheless agree on everything the editor said, but for reasons that the editor didn't foresee. The doctor's apportionment to activities of daily living appears vague and speculative. Yes, it is speculative, and that is legally permissible according to citable case law. Should this become the standard? Well, this is the standard. It would be difficult to obtain an award without apportionment in almost every case unless the worker lived a totally immobile life. Yes, 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 I completely agree with you. I think you're right, Mr. or Madam Editor. It appears so long as the magical words such as best medical judgment and reasonable medical probability are used, virtually anything is a permissible basis for apportionment. It's funny that they should use the word any. The case Escobedo, the en banc apportionment case, the first one to come down after SB 899, said that we could apportion to anything, and they actually underline and italicize the word any. So it's funny that the editors should say that if this should become the standard, actually what is the standard, would allow apportionment in virtually every situation. Well, I've got lots more that I would love to talk about, but I am fresh out of time. Hang on a second. I think Tammy wants to say a few words to you, and please have a wonderful afternoon.